pursuant to the statute, pursuant to the case law's interpretation of that statute, as it pertains to any item or matter pending or pertaining to a grand jury. So the Commonwealth felt that it was appropriate, given the subject matter, and as it would with anything pertaining to any grand jury, particularly what is purported to be an active grand jury presentation. The Commonwealth felt that the protective order impoundment was appropriate. Pursuant to the case law, I would ask that the motion be allowed.
All right, and just so we're clear, because you referenced it, I did receive, as you're all aware, correspondence from the U.S. Attorney's Office in Boston. We appreciate the opportunity to be heard, having reviewed all of the materials referenced above. The Department of Justice and the U.S. Attorney's Office for the District of Massachusetts do not object to public disclosure of the correspondence at issue in the pending motion. So with that, I'll hear from you now, Mr. Yannetti.
I appreciate that. Thank you, Your Honor. May it please the court. Your Honor, the Commonwealth seeks to suppress from public disclosure the contents of the 6 letters that were produced for the defense on December 4th of 2023, as well as the additional 2 letters that were produced on January 4th of 2024, which was the day before our last court appearance. I would suggest that it's ironic, however, that in order for this court to determine whether the drastic remedy of keeping those letters hidden from the public is warranted, the court must first consider the content of those letters. And in order for me to be able to argue against this motion for a protective order,
just so it's clear, I have not seen those letters.
Okay. I still, Your Honor, I must discuss the content of those letters to some degree and argue to this court why a protective order makes no sense in this case. And with your permission, I'd like to divide my argument on this issue into 2 parts. First, I will argue to the court that the Commonwealth has not met the legal standard necessary for the issuance of a protective order. And second, I will argue to the court that a protective order will accomplish nothing in this case.
All right, so which part do you need to reference the letters? Because I'm going to need to read them before you reference them.
So with regard to the first part, which is that the Commonwealth has not met the legal standard, the only way to discuss whether they've met the legal standard is to know what the letters are.
Right. So I need them. I don't have them, and so you would be arguing the content of the letters in the first part. All right. How about the second part of your argument? Would you be arguing them as well? Nobody provided them to me.
Why does she never have anything she needs?
Yeah. Your opposition, and I don't have from anyone. So how about the second part of your argument, Mr. Yannetti?
Well, it does touch on that, Judge. You know, the Commonwealth has revealed some of the contents of some of the letters, but I
and she's
point out what they haven't revealed. You know, and just so it's clear, I'm not going to be quoting the letters at length. I'm going to be talking about the subject matter of the letters. In my view, I don't know that the court needs to read the letters first, but I'll leave that to Your Honor.
All right, but you said you're going to reference them, and the whole motion concerns those letters. Do you have them, Mr. Lally? Do you have them with you?
Well, some judges just has a shitty way.
Going to, in general terms, just give me a couple of minutes now to just look through them, Mr. Yannetti.
That's fine, Your Honor.
No, she does this all the time. She always never had. I didn't have that, or no one provided that to me. I haven't read that yet.
Yeah, I don't know if it's the state or the defense's obligation to deliver it to them to her, but she knew it was the motion hearing today was about suppressing these 6 letters, so she should. Why didn't she ask for them? That's my thing. Yeah. I think there's 4 things on the docket today. That's to suppress the letters and not to suppress the letters, and I can't remember the last 2. These are the letters pertaining to the federal investigation into the police department. It's been the big talk is, will the feds save Karen, because they're investigating the Canton, I believe it's the Canton Police Department. They probably won't. It's probably not directly linked to the Karen Reed case, because it was, as far as I know, started before this case started running into all this trouble. But the DA has written 3 letters and have three responses, as I believe it is, and those the defense wanted to bring out in the open, and the state don't want it out in the open. But the feds have said it's fine with us. Yeah, if the state doesn't do it by the defense, because we know in this case the state is really, really, really slow. It'll be fun to know if the lab have done the testing they're supposed to do, because I believe wasn't they ordered to deliver it to them yesterday or the day before?
I thought so.
I believe it was, yeah. But the state is really, really bad in this case.
So far, there's one letter that I'm going to need more time on. It's a letter dated May 18th, 2023. The others so far, I'm prepared to let you argue in general terms.
With regard to that May 18th letter, Your Honor, that is not one that I will be.
Okay, that's why I brought it up. Okay, so.
Right. Why I responded.
I like that Giannetti fella. He seems really competent. Yeah, there are people there, but it's a Zoom meeting.
So you're also not going to reference the response to that letter? June 1st?
Correct, yes. Yeah, those deal with the Office of Professional Responsibility.
Okay, I just have 2 more to just quickly take a look at.
Well,
So clearly she was able to get copies of them. So why didn't you 10
No, she
million
just
years
got them
before?
she just got them from the state.
Well, yeah. Why didn't they give them to her beforehand? She
Didn't ask for them, and they didn't provide it. So
I don't care. That's annoying.
she does that a lot, especially with. She seems to not like Giannetti, and she seems to not like the female lawyer.
Mhm.
And I bet some of the people who is into it
Right, so I'd also
will know
like
these
some
people.
time to take a look at the June 21st and August 3rd letters. Were you planning on referencing them?
I'm going to reference them in terms of a subject matter, but not the details.
So the letter dated August 3rd, 2023. Do you have that in front of you, Mr. Yannetti?
I do, Your Honor.
All right, so the second paragraph, the second full paragraph, I'm not going to allow you to reference that right now.
Your Honor, if I may, the letter may be visible on the Zoom screen.
I've got the,
Just when you're holding it, you can see
see
it.
the light can see through it because I've got the print facing me.
You could see a portion of the print, that's all, just from the
Okay.
angle.
All right.
No, what? Well,
All right, so
the
with
state
that,
has a motion to suppress, and the defense has a motion to not suppress. So,
Well, if they have
Yeah,
a
it's a
motion
Zoom
to
call.
suppress, they should have
Subject
provided the
matter
letters,
of
stupid
the
idiots.
yeah.
Okay, that's fine, Your Honor.
In this case,
in terms
always
of the
make sure you
parts
give
of
it to
my
her.
argument, I will first argue that the Commonwealth has not met the legal standard that is necessary for the issuance of a protective order. The second part, I will argue to the court that a protective order will accomplish nothing in this case because the contents of those letters will be revealed in full during oral argument before the public on the motion for sanctions that we filed immediately after our last court appearance. So first, Your Honor, I urge this court to deny the Commonwealth's motion for a protective order because they have not met the necessary legal standard. In their motion, the Commonwealth cites Mass General Laws, Chapter 4 and 27D, which stands for the proposition that interagency memoranda or letters relating to policy positions being developed by an agency should not be considered public records. An agency's discussion of policy positions is akin to an attorney's discussion of trial strategy. It's not work, it's work product, it's not discoverable, and it's not a public record. But that is not what we have here. The 8 letters that have been provided do not discuss at all policy positions being developed by any agency. To the contrary, these letters fall into 3 categories. Category 1 are 3 letters consisting of a back and forth between the Norfolk County District Attorney's Office and the U.S. Attorney's Office for the District of Massachusetts regarding whether the U.S. Attorney would release any information to the DA about their investigation. Category 2 are 4 letters back and forth between the Norfolk DA and other agencies wherein the Norfolk DA is complaining about the fact that they're being investigated and asking for the U.S. Attorney to be taken off that federal investigation. And finally, category 3 is 1 letter from DA Morrissey to the new special agent in charge of the FBI asking him to have his agents speak to the state police who are under DA Morrissey's command. To be clear, there is no confidential grand jury information in those letters. There are no records, orders, and subpoenas relating to any grand jury that should be kept under seal. There are no policy positions being developed or discussed. There is nothing in those motions that's the proper subject of a protective order. And I suspect that is why the U.S. Attorney has no objection to those letters being revealed to the public. That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the
How much are you going to bet she's not going to
They should be unsealed.
Going to make a ruling right now?
But assume for a moment that this court decided otherwise and issued the protective order sought by the Commonwealth. I ask this court, what good would that do? How effective would that be? The answer is it would not be effective at all. And in many ways, it would be meaningless. I say that, Your Honor, with no disrespect intended. I say that because that's the reality of this situation. Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date. And I ask this court to consider what that hearing will look like. That hearing will prominently feature the contents of all of the 8 letters that are at issue here today. The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters. And I assume that that is the reason that our motion for sanctions is currently—
Sounds like there's fire in there.
As well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation as a result of his conduct in this case. Those letters prove that he knew that, even before the U.S. Attorney ever confirmed that there even was an investigation. And Your Honor, on that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reed defense team participated in a conference call yesterday with a representative from the U.S. Attorney's office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please consider what that means for the upcoming hearing on our motion for sanctions. The anticipated nature of that hearing bears directly on the ruling that this court will make today on the Commonwealth's motion for a protective order to keep the 8 letters impounded. We have the 8 letters.
Yep.
We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle. Those letters are powerful evidence that we will use to publicly support our motion for sanctions. My client is entitled under the Constitution and the Massachusetts Declaration of Rights to present as effective a defense as she can to these false charges. She's entitled to lawyers who will zealously represent her within the bounds of the law. She is entitled, in short, to have the contents of those letters made plain to this court, both in writing and during public oral argument on our motion for sanctions. And that argument will happen in public, whether this court issues a protective order or not. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. But the Commonwealth wants to keep the remainder of the letters hidden because those letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Read. So, Your Honor, because the Commonwealth has not met the necessary legal standard for a protective order, and because a protective order would be effectively meaningless here in any case, this court should deny the Commonwealth's motion.
All right, is there a response from the Commonwealth or no?
No, Your Honor.
Okay. All right, so I'll take this under advisement. I do need copies of these letters, so
I'll take it under
Mr.
advisement.
McDermott can
Of course.
make copies and then hand them back to the Commonwealth. All right, so the second motion is the Commonwealth's motion for Rule 17 for records from Boston Magazine. And I understand there's counsel here from Boston Magazine. If you'd come forward, sir. Hi, you can stand at the podium or council table, wherever you're comfortable. In a minute, I'm going to ask you your name and I'm going to hear from you, but I do just want to state that I appreciate that today
No, she's
I
always
did receive a response
taken it under advisement.
from Boston
Last
Magazine. I
time she did
received
rule in favor of
the-
them in
there's a
2 out of the
memorandum,
3
there's a
things they
limited
wanted.
Opposition, there's affidavit, there's a memo. I found all of this helpful. I did have the opportunity
Again,
to
last
read it
time she allowed
sometime,
2 of the 3
before the hearing.
things they asked
But
for
I
after
do
at
appreciate the response. More
advisement.
importantly, I appreciate you being here. So could you tell me your name, please, sir?
My name is Robert Birchie. I'm from the firm of Claris Law.
Could you spell your last name, please?
Last name is B like boy, ERTSCHE.
Okay. All right. Could you
I'm
tell?
representing MetroCorp, doing business as Boston Magazine, and also the reporter Gretchen Voss.
All right. So there is the Commonwealth filed a Rule 17 motion. You, as the third party or the record holder, have a right to be heard. So I'll hear you.
Thank you, Your Honor. There are really 3 documents at issue. 2 recorded interviews, one 4 hours long, another one 2 hours long, that are largely, almost entirely, on the record, were interviews with Ms. Read in the presence of her counsel.
Okay, you say almost entirely on the record. Could you
there
explain
are a
that,
few-
please?
I'm sorry. There are a few interjections by counsel, and there are also a few areas where counsel asked, or Ms. Read asked, that certain information be kept off the record.
Okay.
So if those were to be produced, we would ask for the opportunity to redact those.
Okay, I understand that. What's the third or the second category, the third records?
The third is a interview with Karen Read alone at her home between Gretchen Voss and Karen Read that was not recorded, for which there are handwritten notes. And that interview is entirely off the record, subject to the parties agreeing to put anything on the record afterwards if they wanted to, but they did not. And no statements of Ms. Read from that interview appear in the article.
Okay.
There's also a 4th category, Your Honor, that just I became aware of last night, which is that there are a limited number of voicemails and texts between the reporter and Ms. Reed that were also considered to be off the record unless otherwise agreed.
Have those been maintained?
They have been maintained.
All right, thank you.
The argument that I'd like to make, Your Honor, really has three parts. First, that the Commonwealth's request is unreasonable under Rule 17A2
Okay,
because it really is just a fishing expedition. The second is that the documents in question are privileged under the common law privilege that permits a reporter under certain circumstances not to turn over unpublished notes and outtakes, and that's especially so if they're confidential. We are not, to be clear, opposing disclosure of those two interview audio tapes.
Okay.
Counsel was present, subject just to the redactions that I previously mentioned. And the third point I want to make is that this case really differs from many others dealing with the reporter's privilege due to the degree of harassment that this reporter has already experienced due to her objective coverage of this case.
can you tell me about that?
I'd be happy to, Your Honor, and she discusses it in her affidavit as well. She has received emails, she has received voicemails, she has received threats to herself.
But I thought it was only the turtle riders who harassed people.
Inappropriate, shall we say, texts with photographs that have been altered.
Have these been to her private accounts or her professional?
To her private accounts, I believe, yes.
Okay,
And
Oh, so the Seaweed's going to
and she
put
says
those in
also
prison too?
that she's never experienced in her 25 years of reporting anything like this before. So if Your Honor is all right, I'd like to proceed to the Rule 17A2 argument.
yes, please.
Rule 17A2, as Your Honor well knows, is not supposed to be a discovery tool. It's supposed to be a tool for bringing materials before the court prior to trial for the ease of trial administration. Here, the Commonwealth already has a lot. They've got a long, detailed article setting out, among other things, many statements of the defendant about the facts of this case. And the Commonwealth has said that it plans to introduce those statements and records at trial. But their argument for more is simply that the article is such a gold mine, there must be more. And that's unlikely, first of all. The article set out the positions of both sides in a very comprehensive and balanced way. You can be sure that if Karen Reed had confessed in her interview with Gretchen Voss, that would have made it into the article. This is a fishing expedition because, as this court has already noted in this case, Rule 17 is not supposed to permit a general fishing expedition for evidence not yet obtained. And the extra that the Commonwealth asserts might be found really isn't very applicable. They talk about nonverbal conduct. Well, they're not going to see nonverbal conduct in an audio tape, body language, physical reaction to a question. The same thing, these being only audio tapes, they won't reveal that. And there are further arguments about Rule 17A2 in my papers. With respect to privilege, as far back as 1971, the Supreme Judicial Court said that a court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses, including by too broad of subpoenas. And that was in Re Pappas case, 358 Mass 613, of the case that ultimately, when it went to the Supreme Court, became Brandsburg v. Hayes. Now, before the court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses by too broad subpoenas, that's stated in Pappas. And the court may take into account all pertinent circumstances affecting the propriety, purposes, and scope of the inquiry and the pertinence of the probable testimony of the particular witness. And in particular, the Pappas Court said it may be argued that use of newsmen as witnesses is likely to
This is the paper's lawyer, because they want all of the notes pertaining the interviews she did, but they're saying this is privileged information, so you can't use it. And he's arguing that right now, that the press have certain leeways.
Results in unnecessary or burdensome
Boston Globe.
or gratuitous use of their work product, where the testimony of police or other witnesses would suffice. This, if shown, a presiding judge may consider in his or her discretion. Underscoring that point, when the U.S. Supreme Court affirmed Pappas, it did so, quote, subject, of course, to the supervision of the presiding judge as to the propriety, purposes, and scope of the grand jury inquiry and the pertinence of the probable testimony. In fact, in Brandsburg v. Hayes, the Supreme Court made a majority opinion, but it depended on the concurring, to make a majority, it depended on the concurring opinion of Justice Powell, who wrote, if the news person is called upon to give information bearing only a remote and tenuous relationship to the subject of the investigation, or if the news person has some other reason to believe that his testimony implicates confidential relationships without a legitimate need, he will have access to the court on a motion to quash, and an appropriate protective order may be issued. There is no law that subjects the editorial process to private or official examination merely to satisfy curiosity or to serve some general end, such as the public interest. Now, since then, as the case law has developed, in 1980, in the case, in the matter of Walter F. Roach, the Supreme Judicial Court stated that a judge is obliged to consider the effect of compelled disclosure on values that underlie the First Amendment and Article 16 when considering a request to compel information from a reporter or a news organization. They went on in 1991 in the matter of the matter of John Doe grand jury investigation, to say that this balancing requires balancing between A, the public interest in having every person's evidence, against B, the public interest in the free flow of information, which can be implicated by needless disclosure of sources or confidential information. In that case, Doe affirmed an order quashing a grand jury subpoena issued to a news reporter in a murder investigation where the information sought had, quote, according to the court, low likelihood of benefit to the grand jury when balanced against the public interest in the dissemination of information. That's Commonwealth against Doe, 410 Mass at 602. There's also the Commonwealth against Bowie case from 1995, affirming a trial court order quashing a subpoena issued to a reporter by defense counsel in a murder case. So those two cases, I'd say, are exactly on point. Now, here, Ms. has to some extent performed her own balancing test. And after considerable discussion and consideration, she decided to waive her privilege as to the two recorded on-the-record interviews that took place where the lawyers were present, except for those sections that were lawyer colloquy or designated to be off the record. But she asserts the privilege firmly against production of the handwritten notes of an unrecorded, off-the-record interview outside the presence of counsel. I'd submit, Your Honor, that her notes of that third interview are unnecessary. She's not an eyewitness to any events in the case. She's provided a detailed article that provides a roadmap to Ms. Reed's statements and is set out.
Aiden can't afford this guy.
Production under these circumstances really does threaten legitimate interests. Some of those set out in the affidavit of Chris Vogel, the editor of Boston Magazine. Judicial intrusion into the news gathering process, the disadvantage of a journalist appearing to be a research tool of the government, the disincentive to the media to save notes and to interview outtakes if such can be casually compelled, and the burden on journalists' time and resources. And my client would attest to you that already the burden on time and money has been more than they care to bear. Although they do understand that under normal circumstances, the Commonwealth is entitled to evidence when there are proper circumstances. All of these interests, along with the harassment campaign against the reporter, disincentivize the media from engaging in objective investigative reporting. So there's a principle that is at issue here, and it's the ability of the press to continue to perform their constitutionally recognized role as the fourth estate. Now, there's an additional argument on this, which is recently revised federal criminal guidance that supports the denial of the Commonwealth's request for the off-the-record interview notes or for any unpublished material. The petition for the promulgation of rules 395 Massett 172 in 1985, the Supreme Judicial Court said, in cases like this one, where the reporter has no personal knowledge of the events about which he is called to disclose information, it may be appropriate for the trial judge to consider the guidelines of the United States Department of Justice contained in the CFR. And the rule, as revised in 2002 from the Department of Justice, declares that, quote, the use of compulsory legal process to seek information from or records of non-consenting members of the news media constitutes an extraordinary means, not a standard investigatory practice. And it goes on to say that the department may not use compulsory process to obtain information from or records of a member of the news media, period. Now, I'm not saying that that is binding on this court, but it is, I think, persuasive from the nation's federal police authorities. So in conclusion, I ask that the court deny the Commonwealth's request as it pertains to the handwritten notes of the off-the-record interview and as it applies to the lawyer colloquy or off-the-record statements in the two audio-recorded interviews. Voss and Boston Magazine do not oppose if the court exercises its discretion to allow the remainder of those two taped interviews to come in, since lawyers were present and on the record. And as to the texts and the emails, if any, voicemails, I'm sorry, those being also under a promise of confidentiality, we would ask to withhold.
All right. So is Ms. Voss willing to still provide the 4-hour interview and the 2-hour, the 2-hour interview that are on the record? She's still willing to provide those?
Willing to provide the recordings, yes.
Okay, and how long will it take for you to provide those?
He's
some redaction
Yes.
needed. I'm not quite sure how that gets conducted.
Okay.
he's there on behalf of the journalist who interviewed her.
Okay.
Possibly less if necessary.
All right. All right. I'll hear the Commonwealth and then I'll give you a chance to be heard again, sir, if you want.
Thank you.
All right, Mr. Lally.
Thank you, Your Honor, the nature or the chilling effect on news gathering the council alludes to in the motion in opposition as well as in argument, the Commonwealth would submit is speculative at best. I would refer the court to the decisions that are cited by counsel in the opposition as well as sort of ancillary to those, the Brandsburg and the Jennings decisions as well. They're federal cases, but essentially what they state is that the state's interest in criminal prosecutions outweighs First Amendment concerns regarding confidentiality, particularly whereas here, the source itself is not confidential. So we're not talking about a confidential source. We're talking
Pixie.
about potentially confidential
Hey, Pixie.
information. But the notably, what's cited to our federal cases because there is no reporter privilege in the Commonwealth of Massachusetts. It doesn't exist. What I would submit based on the Commonwealth's motion in submissions that there is not even a hint or a scintilla of a hint of bad faith or harassment by the Commonwealth, nor is this a fishing expedition to cull through a vast array of irrelevant information. What we're looking for is statements of the defendant. Not asking for statements of the defendant's attorneys or anyone else. Not asking for the reporter's impressions or thoughts or any other things that may be contained within her notes. The statements by the defendant to this person are relevant, they're admissible, and the Commonwealth's request is specifically tailored to just those statements. The timing of the statements the Commonwealth would submit is also instructive and salient in this sense, in that we're not talking about some sort of vacuum where there's the potential future prospect of a criminal prosecution. These are statements that are made while there is an active criminal prosecution ongoing. The defendant is obviously aware of that. So 2 of these 3 interviews, she's present with her attorneys, who presumably know that there is no reporter privilege in the Commonwealth of Massachusetts. And yet she makes these statements voluntarily. She agrees to these interviews voluntarily. She's not compelled in any way to do these interviews. But the fact that these interviews exist and the fact that there are statements by the defendant that specifically pertain to this case makes them relevant, makes them admissible. And that is why the Commonwealth is specifically requesting those particular items. As far as these other items for which the record holder has an opposition, the Commonwealth has no issue with the record holder properly redacting or vetting through the content to ensure that the only thing that is provided is what the Commonwealth is seeking, which is just statements of the defendant. Nor does the Commonwealth have any issue with any sort of in-camera review by the court as far as deeming whether or not any of those statements as provided are relevant. But the Commonwealth is entitled to these, has met its burden under Rule 17 when asked that the motion be allowed.
So in the balancing test that the law says I have to do, shouldn't I consider the danger or personal risk to Ms. Voss, considering what's already occurred to her?
So, and I'm not in any way trying to minimize that, and I would submit that yes, I think that is something that the court needs to consider in its balancing test. However, I think what the case law also says is that those types of concerns yield to a criminal prosecution in this case. And in part, again, just based on the limited specific scope of what the Commonwealth is requesting. Again, I understand Ms. Voss's concerns when it may come to her notations as they apply to her impressions or her thoughts or things that she observed or whatever the case might be as to whatever her notes contain. But the only thing that the Commonwealth is seeking from those notes is statements by the defendant. That's it. So as far as any other things that may be contained within her notes, Commonwealth's not interested in those, not seeking those, not asking the court to order those in any way, shape, or form. And again, as it pertains to any of those items, the Commonwealth would suggest that in this case, I think an in-camera review by the court would be appropriate based on whatever is submitted, particularly as it pertains to that third. I don't think there's as much of a concern, and there's no real objection that I can surmise as to the first 2 recorded interviews. But as it pertains to the notes, I think an in-camera review would be appropriate.
Well, we don't know who made the threat, even though Grant is saying it was Turtle Riders who did it.
Things, Your Honor, very briefly.
Sure.
I'm not sure that the Commonwealth heard what I said, because Ms. Voss does not oppose the release of the 2 interviews, save the off-the-record portions of the lawyer.
I think he's talking about the 3rd interview.
Yes, but I'd also refer to any part of the first 2 interviews deemed off the record that would contain any statements by the defendant. So I don't know what the off-the-record portions contain, but if they contain statements by the defendant, the Commonwealth would be seeking those as well.
Well, that gets to the next point, really, the distinction between confidential sources and confidential information. And I'd submit that that's a distinction without a difference. The same.
But is there any case law that supports that?
I don't have it at the top of my head, Your Honor, but I do believe.
Please feel free to provide it.
All right. Finally, I want to make clear the Boston Magazine and Ms. Voss are not arguing that the Commonwealth is acting in bad faith. In fact, I appreciate the way in which they narrowly put their subpoena in terms of only wanting statements of Ms. Reed and not of anyone else, not from counsel and not from other things. I do take issue with the notion that the Massachusetts law doesn't recognize a common law privilege. They do. They recognize an evolving privilege.
Because this is a different set of letters. This first was to squash the Fed letters. This is to get into what the reporter wrote down during the interviews with her. It's different matters. It doesn't pertain to the same thing.
It's really flexible enough to take in the particular facts of every case. And the cases are uniform in saying that the judge has a duty in the civil side to enforce Rule 26C with particular rigor, and on the criminal side as well. The question of harassment comes up as part of that test. And it's true. We're not saying that the Commonwealth has harassed
Right.
Ms. Voss, but she has, in the unique circumstances of this case, suffered and will continue to suffer harassment to the extent that her role becomes large. And ultimately, Your Honor, there's a lot there. And we're not saying the Commonwealth is overreaching, and we're not saying that the Commonwealth is in bad faith, but we are saying that the Commonwealth is asking for too much.
Okay. Thank you very much. So you say it'll take you 2 weeks to get those first two redacted and sent in. And if you want to respond with at least that case, so I'll take 2 weeks then to decide this. So the sooner you can get me anything else you want to get me. I am concerned about the safety of the reporter. She shouldn't have to suffer harassment or any danger as a result of this.
Of course not, Your Honor.
All right.
Counsel,
So,
is February 1st, which is 2 weeks from today, is that doable? That's doable.
okay. All right. Thank you. So, Mr. Yannetti, we need to get a date for the remaining two motions that were filed by the defendant, the motion to dismiss and the motion to disqualify the district attorney's office and sanctions. All right, so as you probably know, we're in the middle of a trial that's going to go a few weeks.
You have another date on the 15th of February.
Can you suggest a date?
I can. How about,
May I interject, Your Honor, with regard to a date? I know that our final pretrial is February 15th. Our request will
February
be that-
15th? I thought it was February 26th.
Nope, 15th and maybe
February
26th.
15th and February 26th.
Okay.
So you're both right.
Yeah.
Well, that actually fits in with what I was going to ask, because our request would be for the motion to dismiss and the motion for sanctions to be heard on February 15th. I'll tell you why, Your Honor.
Of course.
One thing that I did not mention regarding the phone call, the conference call that we had yesterday with the U.S. Attorney, is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to
Did
trial.
they give you a date, Mr. Yannetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
All right. Does that date work for the Commonwealth for that purpose?
I'm sorry, the 15th?
Yes.
That should be fine.
Jim, is that at 2 o'clock?
It is, it's at 9 o'clock.
All right. Assuming we're not on trial, it'll be at 9 o'clock. If we're still on trial, it will be at 2.
That's fine.
The only issue there is that I do have a trial before Your Honor that's scheduled for February 13th. So,
Right. That's the case that I expect we'll be on trial for. And if that's the case, we have
You
to
set the
finish
time
that.
last time,
We've got a very
Lally.
busy
Can't you
trial
remember?
schedule. So if we're on trial, we'll see you at 2 o'clock. All right. So stay in touch with Mr. McDermott. All right, is that it for today then?
That's it for the Commonwealth. Thank you, Your Honor.
You all set, Mr. Yannetti?
Yes, Your Honor, thank you.
Okay. All right, and Mr. Birchie, I appreciate you being here, sir. All right, hearing's over. Jim?
Thank you. February 15th.
Okay.
Goodbye.
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 Well,
Uh-oh.
that was interesting.
It was something.
Confirmation that Morrissey is being investigated.
Yep.
The investigation is ongoing. That's interesting. And the feds will be releasing evidence to the defense. They had a meeting today. They will be releasing evidence in the beginning of February, which will lead to the defense arguing that the case should be dropped and sanctions against Mr. Morrissey. So that's interesting. And then the Boston Globe said that the reporter had been harassed like never before. They were afraid that the state was going on a fishing expedition by if they released everything, every note about how she looked or how she was carrying herself. They were willing to release the 2 and 4 hour audio portions with redactions, but they weren't willing to release the handwritten notes because they thought that was privileged information. And the state said, no, we're not going on a fishing expedition. We just only want the statement from the defendant.
All right.
Yep, we believe him. And concerning the harassment of Ms. Voss, yeah, of course, the judge should take that into consideration, but no, don't take that into consideration. Just give us all the notes, give us everything. But they're only after statements by the defendant. But the Boston Globe said you can have the audio from those 2 and 4 hour interview, but they still said there's a question about what is confidential information and an informant, and that the harassment must be taken into consideration. And if you go to I won't call it the opposite side because I don't have a dog in the fight. I'm just an idiot from Denmark. But that Grant guy who's always live tweeting, he said that the Boston the newspaper's lawyer said that it was the Turtle Boy side who had harassed her. The worst harassment ever. I can't. Did you hear that, Jamie?
No, I didn't hear about saying worst ever and stuff like that. I missed that part.
No, but it wasn't said. But that idiot is live tweeting and is lying again. We just had the audio from the last court hearing. You and Dave read the testimony.
Oh yeah, I was.
He lied about that as well.
He's a liar. He's such a liar. He
lies, and he before today he said, "Well, I'm like a sketch artist. I embellished a bit to give it a little more flavor." And I wrote, "Yeah, you're like a sketch artist if you make." If you drew them the wrong color, the wrong gender, the wrong hairstyle, the wrong body type, because he's such a fucking Grant. And Yamaha Biker, hope you're doing well. And Dave has the link, so Dave, if he wants to jump on, he probably missed that I put it up for him. So yeah, I know his mom. I'm not can't off my head. Yes, but yeah. But that he has a press pass and is sitting there pretending to be a reporter. And he clearly lied. He wrote that the lawyer said it was turtle riders who had harassed this journalist. Why would they harass a journalist who's just making an interview with Karen Reed?
Yeah. There would be no reason for that.
It's such a stupid argument that I really don't understand why he could do that.
So I test.
I don't know what to say, but of course I'm biased. Of course I watch the trial, try to put my spin on it, because or else you could just watch channels without commentary. But why? I would never say that the Fed letter made sure that Karen Reed is going free, because they didn't. The only thing the Fed letters apparently shows is there's an ongoing investigation into Mr. Morrissey, and that's going to be very interesting.
Oh, for sure.
I have said many times, I know a lot of people are saying, well, the feds will clear Karen Reed. I have said many a time, don't believe in abracadabra. Make sure you dot your T's and cross your I's. Mm-hmm. And people are saying, no. But of course, I have my biases. But that, I'm sorry to say it, and I don't use hard words enough or often, but that's just idiotic. Sitting there live tweeting, because so many people follow him and believe now that Aiden's crew has been out there harassing a woman. Janette said the feds won't allow this to go to trial. No, they didn't say that. He didn't say that. He said that they had a meeting today with them, and it's ongoing, and they will be releasing the stuff before the next hearing, where he will have his motion to drop the case. Yeah. Tri-fuel generator. Yeah. Shenanigans all over the place. Dot your I's and cross your T's. Exactly, Brian. Self-deprecation doesn't suit you, nor does it fly. Your input is both key and appreciated. Well, but I'm not a lawyer. I have no legal, I only use what I feel is common sense to evaluate the information I get. And I know, and Grant probably does the same, but I try not to openly lie about what's said. I would rather sit here and tell you, if Giannetti had said, well, there's nothing in the Fed letters, I would have said that open and honestly. I wouldn't have said, well, it's going to be, it's not the feds who run the trial. It's the judge. No, he said they will be releasing it, and they need that for their motion to dismiss. That's what he said. Yeah, he said he needs the information in the motion to dismiss, because whatever comes out, well, let's just do it again, because I'm pretty sure that he just said that he will be needing the Fed's letter to...
particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
All right. Does that date work for the Commonwealth for that purpose?
I'm sorry.
This attorney is that they notice.
Okay.
We have February 15th and February 26th.
Okay.
This is where he talks about the U.S. attorney.
Well, that actually fits in with what I was going to ask, because our request would be for the motion to dismiss and the motion for sanctions to be heard on February 15th. I'll tell you why, Your Honor. One thing that I did not mention regarding the phone call, the conference call that we had yesterday with the U.S. attorney, is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties, because in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Giannetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we probably get this information sometime in early February. And I don't want to argue particularly the motion for sanctions, without seeing, don't probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact. We probably get this information sometime in early. My expectation is we probably get this information.
Give you a date.
There's an active investigation, and they're going to release information to both parties because, in good conscience, they can't allow this case to go to
Did
trial.
they give you a date, Ms. Tianetti?
Okay.
I see. I hear it. Yeah.
They did say that it could take a conscience, and they're going to release information to both parties because, in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Tianetti?
They did not, but they did say that it could take a week or two, I believe, to go through the 2-week process. My expectation.
Thank you all so much. I was wrong. As I said, I would rather listen to it again and admit I've made mistakes than sit here and say. But again, that's his. That's his information. So, but if that's correct, that's the bombshell people are waiting for. But again, do you trust this lawyer will take that under advisement? I advised at Jamie. What's the word I'm looking for?
Well, do we really think that that's going to happen, though?
I don't trust this later.
That's the whole thing. Is like,
yeah, it's on Bev. It's on Bev.
Hold your breath, people.
Advisement. Yeah.
Yeah.
My guess, based on that, they have evidence that would exculpate her or incorporate someone else in the money. Yeah, but again, now we're into what have happened to us. Dave is still going on. It's still go. Dave, where is he? Is he live?
No, Dave. It was Dave. That asked the question.
Oh, sorry. The Treehouse trial is still going on. The stapulator is done, and I think they're talking with the DNA expert right now. We'll go back to it, but I just wanted to go through all of that. And yes, they had a conference call with the feds, which was quite interesting. And the feds said, we will be releasing evidence in the beginning of February due to the TUI process. And as I was told, in good conscience, we can't let this go to and then Bev trolls it on.
Yeah.
It's about Morrissey. They said they were told in the letters. No, they were told that Morrissey is under investigation and the investigation is ongoing because of this trial.
Yep.
Well, yeah, Karen has a little more swagger than Tucker. But yeah, that, as I said on X, bombshells be dropping. Mm-hmm. Oh, talking about a bombshell. More of a smexy bombshell than anything else.
How we doing?
There he is.
I heard my name.
Yeah.
And then I discovered that you actually did have a link for me.
Yeah. Been there all day.
I know. I've been doing Zach Anderson and Crumblies and a bunch of other stuff. Dave?
I figured.
What do you think about those?
Yeah, David.
Well, I find it on. I believe the motion to release the federal DA's letters, that's probably going to get granted, especially if it's going to come out anyways. It sounds like there's nothing terribly troubling in them from a legal standpoint. But it sounds very, the way the attorney put it, very embarrassing for the state DA, which is going to be fun to read through. Yeah. And then with the other one's interesting. Actually, it's a very interesting argument. So Karen Read did an interview, and in the interview that went out public, right, the state could just grab that. The state, it just grab it, record it the way we record stuff, and it's no big deal. But they want all the other stuff that, like the notes and the stuff that was said off the record and things like that. That's very interesting. I'm just thinking back to the Jodi Arias trial. They played a lot of her interviews, but they were televised portions of the interviews. There was no behind the scenes stuff. I would have to imagine that there is a confidentiality rule that would apply, but I don't know Massachusetts law. I don't know if it recognizes that. Very good attorney though for the news media person, whoever it was, that the reporter that didn't want to turn over that confidential information. He was very eloquent. He was on point. He's not like some of the other attorneys we've heard argue in this case, not talking about the defense counsel, mainly the state's attorneys, and how they're all over the place. And they don't even believe in their positions, it sounds like. So, no, it was it was an interesting argument. I'd have to go brief it if I was to make the same argument in Michigan, because I don't know what the law is regarding that sort of thing. The general rule is anything you say to anybody can be used against you, right? That's why you don't talk to not only police, but anybody. If you tell your neighbor can be subpoenaed to testify as to what you told them. And to treat reporters in a special light, given the First Amendment, I think does have a precedence in this country. But it's the nuance. It's the, okay, well, you made a report, but you're not keeping your identity secret. But you did say some stuff off the record. So is that discoverable? It's a very interesting argument. And I want to see where this judge comes down on that. That's my 2 cents.
And Stephanie, or maybe Stephanie, thank you so much for your super chat. Thanks for covering the case. Love your opinions and drawings. Well, thank you so much for that.
I come here for the drawings.
Yeah. Jamie just comes for the nudes.
I do.
But thank you so much, Stephanie. You're going on the board.
My hair's a mess. I just got back. It's snowing out. Jamie, is it snowing by you?
Yeah, it started to. And I got an eyelash appointment today, so it needs to stop.
Oh my God. I found something.
What?
Hang on. Let me find it again.
Please speak to how much of a bozo this judge is. Harassment of the reporter, such an obvious shot at turtles. Well, it's
Why is she always never prepared? Probably has a lot
if
to do
she
with
hadn't,
the state, I'm sure, or the Commonwealth.
Yeah, you can say, the defense should have provided her with the letters, the 6 or 8 letters, how many it is. But again, shouldn't the state, because they wanted to suppress it, so shouldn't they do it?
Yeah.
Oh,
They would.
someone drew me a little piggy.
What?
A little piggy.
I'm a little piggy. Brian Fitz, thank you so much for becoming a member. You go on the board as well.
You're a muffin top. Yay.
The little muffin chip.
Little muffin top.
I saw this and I immediately thought of Jamie.
Oh God, what is it?
I turned the volume down so we don't play the music.
I told the volume, let me play the volume.
Look, there's another one. No, that's my phone ringing. Immediately thought of Jamie. I was like, oh, there's some eyelashes.
But why? I would never. That looks ridiculous.
The nails.
And
You could do the nails.
First of all, I keep them short and nice. Because I don't know how people, not to get weird, but how do you wipe your booty with stuff like that? I mean, if girls have them and you know how to do it, cool. But I don't know why.
I just saw those and I immediately thought of Jamie. I was going to tag her on Twitter.
Well, it looked like me too, Mark. Not only Bev, it looks like me. Yeah, that's pink eye waiting to happen.
Yeah, it really is.
That's a lot. Yeah, that's a lot of things waiting to happen.
It's just I don't even know how they see. They look like camels.
I know. I don't know how they. You're talking to me. I don't get crazy eyelashes.
Well,
They're
you do.
very
You ask
natural.
for the stripper length.
I do, but at least I can see.
That's not Jamie.
It is you. I feel like you imagine that when I close my eyes, like everything goes dark, and then, or you're not close my eyes.
Yeah,
But like
yeah. No, this is
I'm, like,
okay.
sitting
So
there.
you're like,
It's
ooh, I
not
look
like
pretty, and then we're looking at you like this lady. Put it back up if you wanted to pull it up. That's how I see it in my mind.
That's not. It's not what happens.
But Dave, what do you think about the last statement that that the feds are going to release evidence before the motion to dismiss this trial, because they won't? I don't know if you heard it, but
Feds to the rescue. I heard that. I mean, I don't trust them as much as I don't trust state police. But you know, the enemy of your enemy is your ally, you know, kind of approach. So I don't
but it was
know.
more Genetti's statement here. If because why would he mention? Come on.
Wasn't listening for the last few minutes because I've been dealing with the media player.
No, because I was yelling at Grant for lying, and then people told me I was lying. So we tried to do it again.
Directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to
Did
trial.
they give you a date, Ms. Tianetti?
They did not, but this case bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to
Did
trial.
they give you a date, Ms. Tianetti?
Yes, he jumps in right when he
Because
says,
in good conscience, they can't allow this case to go to trial without releasing this information is probably where he was going with that. Without providing this information to both sides. That's probably where he was going with it. Not that they're going to stop the trial. First of all, federal courts,
they can't
federal
stop the
DA
trial.
can't stop the trial. Nobody can stop the trial except for that judge right there. But what he was probably saying is can't let this case go to trial without this information being made available to both parties.
But is
That's
it
what I was
unheard
thinking
of?
it was going. That's where I thought it was going.
Is it unheard of that they go in and release evidence from a?
No. What you generally hear about it, though, is you usually hear, and you see it in trials where an FBI agent is called to the stand because the FBI agent helped in the investigation and did testing on evidence that's proving the defendant guilty. And so it's very common for the state and the FBI to be working together, and then the state calls the FBI agent and things like that. What's unusual about this case is that it seems to be the other way around. It sounds like the defense might be calling the FBI agent that tested the evidence and doing things like that.
No,
so
this is pertaining to the investigation into Morrissey. They had a meeting this morning about the investigation into the police department or into the DA's office. That's what he's talking about. It's not the trial.
Oh, it's not the trial itself.
No, I'll just baconate it a little bit more so you can hear it.
The one thing that I did not mention regarding the phone call, the conference call that we had yesterday with the U.S. attorney, is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of.
It is. I would agree.
And they're going to release information to both parties because in good conscience, they can't allow this case to go to
Did
trial.
they give you a date, Ms. Tianetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
Maybe it's some sort of Brady violation. Maybe it's some sort of Brady violation where the DA is withholding exculpatory evidence and not turning it over to the defense, but the FBI knows about it, and that's part of the wrongdoing. That's part of the sanctionable issues. That's part of why this DA's office needs to be recused. Maybe it has something to do with that. That would make sense. I mean, that would make sense as to why the feds would want to release it before the hearing for the sanctions and for dismissal and all this stuff. It could be something like a Brady violation.
If the state dropped it, she would have to sue them to get money. That's not automatic.
Okay. So I will say this, as far as I know, I don't know if it's statewide. I don't know if there's something special in Massachusetts, but in Michigan, if you wanted to sue for a wrongful prosecution, which would essentially what this would be, you have to be acquitted by a jury. You can't do it if it's just a dismissal. Now you can, there's another case or another cause of action called abuse of process, which maybe you'd have a foothold in under Michigan law if they dismissed it. But I don't know Massachusetts law, so just take that into consideration. But generally, you have to have an acquittal, not a dismissal.
Does she seem unbiased? Just wondering if I feel... I don't know if she's biased. I just feel she's unprepared, and she won't be caught on camera having an opinion. Because again, last time she did rule in favor of the defense in 2 out of the 3 wishes for phone records. So she's not all the way against Karen Read, but she seems like she isn't a lot of judges go along with the state kind of judges.
Well, a lot of them come from positions of government authority, like they come from the district attorney's office, or they were prosecutors, or they were brought up within the judicial system. And, you know, the court is a state department, right? It's a state department. So they're all kind of playing on the same side to some extent. And you see a lot of that. And in fact, there's a particular judge locally for me that doesn't play that ball, that makes particularly with warrants. And the police get so frustrated because this judge is like, no, this isn't enough. And he doesn't sign warrants. And the police hate him, right? So why is that? Because they're making them, you know, do their job. Why would you hate a judge? Wouldn't you want a judge that's fair and impartial? But that's not the ones that usually get in those positions. Usually it's the ones that play ball with the state.
And would the feds care about some Brady? Yeah, if they're investigating the department, they would care about Brady.
Well, it might also help them prove their case, right? If they're looking at misconduct by the DA's office, and this particular case is just another notch in the misconduct belt, a ruling from the state court that there was a Brady violation and an involuntary dismissal of the charges against Karen Read would bolster their position if and when they actually bring federal charges against this particular DA and his minions. So to the extent that it benefits them and their investigation and potential charges, yes, they would do that. Or they could do that anyways. I don't know if they would necessarily.
Interesting.
But yeah. So this is all the, you know, I scratch your back, you scratch mine. We're on the same side. The enemy of my enemy is my friend. Sort of situation going on right now.
Yeah, and I think it's really weird that the feds are reaching out to them, calling the defense and saying, we will be releasing to both parties in this case. So again, I'm not saying abracadabra things or anything, but still, there's more to it now, and that the DA wants to keep the letter secret, but the state, the U.S. attorney said no, we don't care. Mm-hmm. That seems like it's not flattering for the DA.
Very interesting, though. Very interesting. Mm-hmm. And of course, this judge isn't taking anything. She's not going to make a ruling right now. She's going to.
No, it's going to be dropped at 7 o'clock tonight, like the last time.
Well, the other thing too is that she did rightfully ask the reporter's attorney for some case law, and he said he'll produce it. And so you don't, and that's the other thing too, is you don't necessarily want a judge that issues edicts from the bench right now, because generally they've had their mind made up or they're wishy-washy. I would prefer a judge that would take something under advisement over one that's going to make a decision from the bench. I want them to sit back. They've seen all the written arguments. They've heard the oral arguments. They're now going to take in a couple more cases. They're going to reread everything in light of what they heard, and then they're going to make a decision. This is the judge that you want. You don't want one shooting from the hip. So, yeah, don't trust the feds. They're cops too. I agree.
Yeah, and that's what I say, because there's been a lot of hope in the feds that the abracadabra will happen with the feds, but still, always cross the I's and dot the T's. Don't believe abracadabra happens. It's as we see with Tucker, our treehouse guy. He believes in abracadabra, just like Brooks did. I just say the magic word and everything goes away. No.
Yeah.
Always make sure you have a hell of a case, and then maybe abracadabra happens, but don't bet on abracadabra.
I got to try to figure out how to make this player work. I got the videos on Zachariah Anderson and there was no sound. So I called the department and they're like, oh, you got to download this player and this and that. So now I got this thing out.
It's probably VLR. It's always that they use because it's a free codec.
This is GOM. GOM.
Call Wilhammer.
Well, I put it into my video editor and there's literally no sound. It's just a video. And so that's why I called them. I'm like, hey, you sent me video with no sound. They're like, oh, no, you got to put it in this player and it'll work just fine. So that's what I'm going to try to do.
Someone called.
I'm just dealing with Discovery. And this isn't like the first time. This is police departments all over the country. Every time I get something from them, it's like, oh, you got to download this extra player.
But Wilhammer is asking if you have a question.
Oh, no, you do.
No, I have no question. I just said you should call Wilhammer and make him help you with the.
I might. I might. If I don't get this working, I might call him. I'll reach out to you if this doesn't work. But it seems something is happening. Where's my sound? I got to figure this out.
Yeah, I think we're gonna jump back and watch the. I passed the guy who talked about how he stabulated, because we know he had normal sized testes for a man his age. And he didn't even cross-examine him, so I don't think there's much in it. Now it's the DNA expert. So I'm going to start from there, and hopefully we'll end before long, because it's almost midnight.
All right, well, you guys have fun. I'm going to jump off and try to figure this thing out.
Okay.
Have you anything coming up later?
No, I don't have anything until Saturday. Jody Day. I might do a Turtle Boy stream at some point tomorrow, but I'm not sure yet. I guess how it plays into my schedule.
Okay.
So
hey, Wilhammer.
All right. Take care, guys.
Hi, Wilhammer. Bye, Dave.
Bye.
See you later. Thanks for stopping by. Everyone, if you aren't already, go join MLS, because he plays a real lawyer on YouTube, and he's a smart guy. He knows a lot of stuff. And if you want someone who's good at cleaning up sounds, subscribe to Wilhammer as well. He is really good at that. But very interesting, short hearing, but very interesting, I would say.
Yeah,
and
can't wait to see what comes.
Yeah, I have to go back and try and clip that part out just for that. Oh, and he's praying too. Namaste, Wilhammer. And let's go back and see if Mr. Tucker is doing better than he